Welcome back to NMP Talk Show, the show that keeps you informed and engaged with topics about your mental health, wellness. And I want to welcome my co-host, Figile. Figile, welcome to the show.
Thank you, Noah. I haven't been on the show in a little while, eh?
Yes.
But it's so good. It feels good to be back. I'm looking forward to this nourishing hour due to the information that we'll be getting on the show.
Oh, yeah, we're always happy to have you over. There's no show without you. And maybe that's why we didn't have a show last week, because you were not around.
Because I wasn't here.
But we're happy that you are here with us. So, where are we streaming today?
Today we are live on our Riverside FM. We're live on TikTok. We are live on YouTube, and we are live on what's this, Telegram. So if you want to raise a question, pass a comment, you are welcome to do so. If you are on YouTube, you just type your comment. We'll be able to see it and read it. If there's a question, we'll answer it. Same as when you are on TikTok, you can just type in your question. I will be able to see it. Those who are on Riverside FM, you can just type your question or comment on the chat box. We'll be able to see it live. And those who are on Telegram, you can just grab the mic, raise your hand, and then our host will unmute you, and then you'll be able to go ahead and raise your comment or ask a question.
Awesome. Thank you for that introduction, Figile. So today's topic, we're talking about wills. What is a will? We're talking about will and testaments. We planning for the future. Especially when you're not around, you need to make sure those that are left behind, they have something to care for them. And today we want to talk about specifically about how to prepare one, what you need to do, all the steps, and why you need to have a will in place. A lot of people don't have. Figile, I don't know, from the background that you have, especially in this field, do you think a lot of people have wills?
80% of South Africans don't have wills in place.
Yeah.
If some of them, they do have wills, but they are not valid. So it's important for us to know whether our wills are valid, updated, when to update it, how to update our wills. Those are the important questions that we need to ask ourselves or talk about. One thing that I find it interesting is that most of us people, human beings in general, we don't like talking about death while we know it's inevitable. So if we don't talk about that, obviously we don't want to talk about wills.
Yeah. Let me do something quickly. Check if everyone can hear us on Telegram. Let me unmute one. Hilda, you can unmute yourself. Are you able to hear both of us?
Yes.
Okay.
Loud and clear.
Perfect.
Awesome. Thank you so much. I'm going to mute you. You can raise your hand later on when you have a question. So let's come back to you, Figile.
Yes.
You said 80% of people don't have wills.
Yes.
I was reading one article that says to have a will, you need to have a wet signature on it. So if I myself type a will and prepare it myself and then don't go to professionals, sometimes it can be deemed not a valid document. Is that true?
Yes or no. So the wet document, the wet signature, it means that your will, whatever you wrote, must be signed, like hand signed. That's what the acts actually requests for a will to be valid, which means if a will is like done electronically or you have an e-signature on it, it's invalid. You can have it drafted, but it won't be valid. So you will form part of the 80%.
No, man, that's the the age that we live in, the what do you call it, the Gen Z.
The Gen Z, yes.
Yeah, we working with digital, signatures and all of that. I mean, why are we not there yet? Where you can draft it on a computer and sign it like e-signature, and
So
it becomes
one of
valid.
the requirements, Neo, is that a will has to be handwritten or
Mm,
typed. That's the
mm,
requirements by by law for it to be valid. So it needs to
yeah.
be handwritten or typed, and then it
Mm,
has the wet signature, and which we say it's actually, I mean, outdated. We're living in a generation where everybody is on technology, they tech savvy. So, I
mm,
mean, I want I'm on the road, I have to sign my will. Now I can sign and have it valid, you know. But
mm,
in
mm,
the court of law, it won't stand because it's not handwritten. There's no witnesses, and your signature is not the hand signature, so it's still invalid. However, there are talks going on to say maybe they need to change the law. You know, they
yeah.
need to
Yeah.
look into it. I think it's a conversation that is already out there to say, look, the Gen Z don't have time. We don't have time. I'm not the Gen Z, but I don't have time, you know. So if you send me a will, you say I need to print it out, I need to sign it. After signing it, I still have to find witnesses to sign on the will. And those witnesses cannot be people who are going to inherit on my will. Where will I get those? Because
Mm,
maybe I'm
mm,
staying with my kids, and my kids obviously are the ones who are going to be beneficiaries on my will. So we
mm.
see it takes a lot of time for us to get there. And that's why most people, they feel like the process of having a valid will is daunting. Hence, even if I thought about it, I don't action it.
Yeah. I mean, the first legislature that was put in place was somewhere around 1953 about the
Yes,
war. And
yes.
and it was amended like a small bit of it in 1996.
Uh-huh,
You
uh-huh.
know how old somebody who
Who
was
was
born
born in
1996?
1996? Over 2 decades.
Yeah, no, I believe something must be done about that because
That's so true. That's
our devices, we use
mhm,
smartphones, smart tablets.
mhm,
Everything is very smart. We
mhm,
do documentation there. If you have a PDF document, you can fill it up on your device and
mhm,
sign it on the device, and it
mhm,
becomes a legal document. And it just baffles me why we can't do that with the world. And maybe that's why the 80%, you'd find that majority of that 80% have wills, but
mhm.
it's not the recognized one according to the
It's
law.
not a valid one. Yes, yes.
Mm,
I mean, some they believe they have it. You know, I had
mm,
somebody coming to me and say, "Look, we do have a soft copy. We printed out the soft copy of a
mm,
will, and
mm,
unfortunately, when they got to the court, the High Court, they requested to have the original copy." So now, with whatever is happening in the world, imagine if you were in KZN where there were
mm.
floods and people lost all their important documents.
Yes.
Where
Yeah.
will you find
The
that important
original.
document now? So, see, if I had a soft copy that is saved on
On the
Google
cloud. Yeah.
Docs, you know, I can be able to download it and have it. Of which
Mm,
now the reality is that for me to have a valid will, if I was involved in the KZN floods, I need to make sure that I've got a new will drafted and I
mm,
have a valid copy, like that is
mm.
what that has a wet signature. If not, unfortunately, your estate will take time to unwind, and it will be administered in interstate, you know, of
Mm.
which that's not what we want.
Hmm. All right, let's invite those that are connected online. If you have any question, please raise your hand. Any comment as well, you can also raise a hand to comment. What I'm interested to find out from you is, do you have a will in place? And if you have a will, how old is that will? Was it,
Mhm.
drafted 10 years ago, and your circumstances have changed, your wealth has increased or has depleted?
Yes, because that's another issue that we encounter. Yes.
The first time you said they can have my millions, and now you don't have any millions. You don't even have
You
cents.
know, you know that's very important now. You
Mm,
find that I might have a will in place
yeah.
now. When I was drafting the will, I had maybe I started working.
Mm.
because that's another thing that we don't look at, to say, I don't have enough assets to have a will. If you
Mm.
are a human being living and you are old enough, you've got people you've got families, you started working, you need to have a basic will, so that your last wishes can be actioned the way you want them to be. Like if you want to be buried, I've encountered situations where family members are saying, she said, he said. And now what's the
Yeah.
proof? Where's the proof to say that's what they said? So now the family members are fighting over a dead body. How are they going to be buried? Where will they be buried? So if I'm leaving, you can just draft a basic will to say, okay, should I pass on? May you please incremate me, or may you please bury me next to my grandfather or wherever, so that there's no fight. You eliminate all these fights that rise when one family member passes within the family.
So what I'm hearing from you is a will is not necessarily what you're talking about your belongings.
It's
It
not only
includes
for
a
your
lot of things.
belongings. Hmm.
Okay. We do have a hand on Telegram.
Okay, let's
Hilda,
hear.
welcome to the show.
Hi, Sis Day. How are you?
I'm good. How are you, Sis
It's like
Helda?
I'm good. I'm good. It's like you read my mind. I must actually come to you and I draft my own will on how I want to be buried.
Yes. And who you want to be your funeral executor, because there's quite a few things that we don't think about. And only when you are no longer there,
Yeah.
it becomes a battle within the family. So yes, you can do that.
Yes.
So do you need
Yeah.
a professional?
I'll have to come to you, Figili.
Yeah.
Yes, you can. You are welcome to come to me, Aushilda.
All right. We'll share your details on
With
the
her.
chat
That's
and
fine.
everything. Yeah. Yeah. So then you said you need a professional to do that, to make it legal. Does it come with costs?
Now, to be honest with you, if you've got a basic will, like how you want to be buried, and you don't have much, you can draft your own will. You can just download the template and put the information that you require to put, because it's just basic. Only when it gets to when you've got assets, you need to do your estate planning. You need to have a professional drafting your will, because you need to make sure that as much as the will is valid, it is liquid as well. You find that people have estates, and on their estate is not liquid. You find that I said I want my assets to be distributed like this, only to find that by the time I pass on, I've got liabilities which exceeds my assets. So now whatever I thought I had is not there, because I didn't plan for it. So if you know that you've got an estate, like you've got assets, you've got investments, you've got a house, you've got a life cover, you've got family members, make sure that you see a professional to draft your will, to assist you in drafting your will. It could be a will consultant, it could be a financial advisor, financial planner, it could be a lawyer, just to make sure that all the aspects are covered.
Awesome. Do you see the chat there? There's a question on the chat box. It's from
Let
Esther.
me see.
Yes. Esther is saying, if you... Okay, you can read it out.
Yeah. Good day, studio crew. Good day, Esther. If a
Good
will
day,
is
Esther.
completed, signed, including 2 witnesses, is that valid but not stamped by the Commissioner of Oath? Yes. Now, what you need to look at, it is a valid will because it is completed, everything is there, it is signed by you and 2 witnesses, and those 2 witnesses are of legal age. I think with me, the legal age will be anybody with from the ages 13 going upwards can be your witness in your will, and they are not beneficiaries in your will. Your will is valid. Now, the safekeeping of the will, because in this area, people can, like, the fraud is there. I can redraft your will and put whatever I want and keep it as signed. So the safekeeping is very important as well, to say, where is your will kept? Is it in a vault? And the will that is in the vault has to match the original will that is within your important documents. Hope I
Wow.
answered you, Esther.
Yeah, no, I think it's covered. You said the beneficiaries cannot sign the will.
No, they cannot. I
Why
mean,
not?
think about it. If my kids were beneficiaries on my estate and they are witnesses, it could be that they drafted the will and they signed it by themselves, so it cannot be valid. But if the will is drafted, they are beneficiaries, and Neo, as much as they don't know Neo, or I meet anybody on the street and signs it, then yes, it is a valid will. You cannot benefit and be a witness on the same will that you're benefiting in.
But the things will be coming to you. Or are they afraid that we might, conspire and
Obviously, Neo, like I
get rid
said,
of you?
I mean, it could be that they plan to get rid of me and they make me sign the
Hopefully
will.
not. Hopefully not.
See, so we avoiding the that will raise suspicions to say, okay, why are you benefiting and the witnesses of the will? Is the will valid? Now, because of that, the court says, no, you cannot be a beneficiary and sign the will.
You make me think now. What's
Uh-huh.
the best practice when it comes to this? Can I draft a will? Like, for instance, it's just me and my wife. We don't have children.
Mhm.
Can I draft a will, get somebody to be a witness, and then share the will with my wife to say, this is the will. Should something happen to me, there you can find it. Or you
I
can have a
advise
copy of
that
it.
actually. I will advise that because in most cases, we tend to hide that important piece of document from our loved ones. Whereas, let's take, for instance, I want to be cremated and the will is with the lawyer. My spouse doesn't have a copy of that will. Only after the will be read way after the funeral, only to find that I didn't want to be buried wherever I was buried. So if that my spouse knows that this is the original document or a copy, give them a copy, to say, okay, this is what happens in the will. You don't need to hide that information. And you shouldn't be scared that they will kill you, of which that's what people tend to do out there. But you actually, I always recommend that your spouse should know what is in your important document. What is it that they are provided for, so that it doesn't raise disputes when you are no longer there.
Okay. All right. No, maybe, yeah. I'm trying to hide how much money I have, stacked somewhere around.
Your
And
will
then she's
won't
not
say how
tempted.
much you've got. So what will be in your will be, I've got an investment with whatever company, or
Okay.
I don't state specifically. If you want everything to come into your estate and then be distributed from the estate, you can just bring everything in and say, in my estate, my spouse will inherit 100%. You don't have to name it individually. But if you've got other people that you want to benefit out of your estate, and specifically maybe your wedding ring, you want it to go to a specific person, that's when you can put it to say, okay, I've got this ring that was, this is how it looks like, and I want it to go to this person. Or I've got this house that I would like to give to this person. Then you can distribute it like that. They shouldn't know exactly what is there, because your will won't state everything that you have.
Yeah. So one of the things I also checked out, while I was preparing for the show, is that like you have components when it comes to a will and testament. Like you have your executor, your beneficiaries, your assets, and your guardianship. How do you integrate all of that into a will?
So now we'll start with the guardian. The guardian, if you've got kids that are under the age of 18,
Yeah.
you should have a guardian. You nominate the person that you believe will be able to look after your kids, and then you just state, and that person should be a person you spoke to. That person should keep a soft copy or a copy of your will, even if it's not the original copy, so that they know what is happening in your life. Because the fact that you nominated them to become your guardian, it's because you trust them, so they should know what is happening. I know with our background we don't like sharing such information, but it is advisable to share such information so that they are not shocked when you are no longer there, that, oh, by the way, I nominated Neo to look after my kids. Because now, if you nominate me to look after your kids, you should tell me where the money to look after your kids will come from. I should know what's going to happen with your house while your kids are still under the age. Should I move into your house, or will you sell your house, or you're going to put it under the trust? So I need to understand before you nominate me as a guardian. And then secondly, should it happen that we both pass on, because by default, the remaining parent is the one, or the surviving parent will by default be the guardian. But what if it happens that we all
Parents.
pass away on the same time? So there should be somebody who looks after your kids. That's the guardian. And then we get to the executors. So like I mentioned earlier, that you need to nominate a funeral executor, because you want certain things to be done according to your will. So you can nominate a funeral executor. So that person is not going to execute your whole estate, but will only execute your funeral, will be the to go to person when it comes to where they want to be buried, how they want to be buried, what needs to be done, and what shouldn't be done. So that's their funeral executor. And then there's an estate executor. You can nominate your own executor who will execute your estate, but it's a lot of work. Hence, they are paid about 3.5%, excluding VAT. That is of your whole estate.
Wait a second. Do you have to pay them first?
No, they are only paid when you are no longer there. So one thing that you can do is to make provision for them to be paid while you're still alive.
So the reason why I'm asking this question, I just wanted to understand about the payment arrangement. I go look for the executor. I find one, and I say, you will be my executor. Do I have to pay him for that, to prepare everything?
Not upfront.
Not upfront.
So
he'll only be paid when I'm dead.
When you are no longer there, yes. Because you can change your executor. Maybe we are in good terms today, but tomorrow we are not. The most important thing is that you need to do is to make provision for how they're going to be paid. Because if you nominate a company to become your executor, it will mean that they need to be paid. So your estate should be liquid enough for them to get their money. Otherwise, your estate will stay there and nobody will touch it until the money is available.
So I know that you're working with these things, and hence you're the best person to answer all these questions.
Hence I'm passionate about the topic today.
And I also don't want to put you on the corner.
Yeah.
But in your experience working with different people and drafting wills, and understand, apparently this week is
Wills Week,
awareness.
National Wills Week, yes.
Yeah. What are the things that you have found, which are the common mistakes that we need to avoid when we're drafting wills?
Only when we're drafting.
Yeah. Okay, you can expand it. Just fly
one common mistake that I've seen is that, one, it's what people not making provision for the things that needs to be paid. So they don't have an estate planning put in place when they accumulating their assets. So you find that when they are no longer there, they assumed. So I see you driving a nice car, staying in a nice house, whereas you've got a bond, the car is under finance, and they're not protected. You don't have a life cover, or you do have a life cover, but it's you just assume that 1 million will be enough. You didn't calculate the needs. And then when it comes to a time when your estate needs to be the time of winding up your estate, you find that, oh, so your bond was 4 million, you are owing 3 million, and now you don't have a house because we need to sell the house, maybe. Your car was still under finance, it's still new, you made only 2 payments, and it is not protected. And you've got all these little debts that you were accumulating along the way. And all those debts are not provided for, so are not protected. By protection, I mean there's no money to pay off those debts. And then
Mhm.
when it's time to unwind your estate, the executor finds that we need to sell the house, we need to put the house on auction because we need to get the money to pay the bank. And we need, or the bank takes the house back. After paying 1 million rent in a 4 million rent house, you have lost 1 million because you didn't make provision for what's going to happen should you pass on that bond or on that house or the car. So those are the things that I find people forget to make provision for, or they don't really think it's important to make provision for. And then another one will be that when you are drafting, not really when you are drafting the will. So we know sometimes we have people who lost their spouses previously and they get remarried. When they were getting married, they didn't clearly specify that. So when I'm marrying now, we have to marry out of community of property, and then we need to have the ANC contract signed because I'm protecting the estate of my previous partner, my late spouse, for my kids to inherit after from the estate. Otherwise, it means I'm bringing it in to the new marriage. So the kids might not benefit. If I don't have a will, it will be administered interstate. So they might lose on that. Or I get stepchildren, and it's nice and fun. We are staying together. We are a blended family. We're growing together, and I pass on. Now, I state that in my will, I don't want them to benefit out of my estate. I want my biological kids to benefit. If those kids can prove that they were financially dependent on you, they can still claim on your pension fund. And it's quite a lot. Some people forget if they were divorced, they forget to change their will after the divorce is finalized. So you find that you pass after the 90 days because you are given at least 90 days to make amendments on your will, draft a new will that will cater for the new spouse. So they forget to do that. And the former spouse will inherit instead of your current spouse. So those are the common mistakes that people make when they draft a will or forget to update their wills. Hence, we say, check it yearly, check if everything is still in order or not. If not, fix it. If yes, it's fine, you'll check it next year when when something changes, because sometimes you find that the beneficiary is nominated on that will, some of them has passed on and the will has never been updated ever since they passed on. So those are the things that people forget to do when they're doing their will or when they're not updating their wills.
Man, this thing, man. No, 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 no. It gets complicated more and more.
It is.
And especially when you now getting remarried. Honestly, I never thought about it. Yeah, and it's quite something that boggles my mind because now you have a new marriage or second marriage, which is new, obviously,
Obviously,
and
yes.
she comes with her children, and I come
Yeah.
with my children,
Mhm.
and my estates. I mean, my will has not been updated. But even if it's updated, yo, and I die, ho- what tension would that cause in the family, especially the children?
A huge tension.
Ish.
Very huge, to a point whereby some family members couldn't see each other, don't want to talk to each other based on that, because you find that my family is taking somebody else's side, but it's something that could have been fixed if you were still alive. Those are the important things that you have to look at. If you're changing your ID, or you want to go and make a passport or something, that should be the same mindset you've got when you've got a will in place.
I, let me hear from you, anyone on Telegram, about this twist. How you feel about it, especially when children are involved. I, I
Involved.
I think I think it's better, although it's still complicated, but it's better if both of you come into a new marriage without children, you know, and then you don't have to fight who gets what, who doesn't get. My biological children must get all of the money, and my adoptive children will not get a cent from it. But now you said in the beginning that it will be a best practice to share a copy
The
of the will.
information, yes.
Now,
And mhm.
yeah, now imagine I said that and I said only my biological children will inherit what I had.
Okay, yeah.
What's gonna happen
Well,
now?
to be honest with you, Noah, these are the conversations I feel has to be had before we can even get married. Especially if you're bringing children in the marriage. So it has to be discussed as to what's gonna happen. So you cannot have the discussion with me before we get married to say, okay, I would like to adopt your children, and then you say they shouldn't inherit in your estate. I mean,
Mm,
it's not making sense. But if you
mm,
say you want to adopt my children to be yours, it means we have to go through with the legal adoption, so that because if it's adoptive kids, they will share equally as my biological kids. Even if you break out of that marriage, they still viewed as my biological kids, so they still has to inherit out of my estate.
can you have two wills? The
No.
first one with the first marriage, and then you protect that. And when you get married the second time, it's not in community of property. So basically, whatever you start in that new marriage will be the second will that will cover the arrangement.
So now you can only have one will now.
Mm,
By law, you need to have one will. Now, what you can do is to update your will to cater for your previous marriage, or if there's kids on your previous marriage, because
mm,
some they've got spousal support. There's maintenance in that. So when I get into this marriage, I need to understand that this person there's people who are financially dependent on him. The former spouse is still financially dependent on him. The kids from that marriage is financially dependent on him. So it needs to be clearly stated on your will. Then you can
right.
cater for the new marriage.
Yeah. Yeah. No. Okay. Let's change gears a little bit. I
Yeah.
think we were running on the third gear now. Let's go the fourth gear, and
Down.
and
Yeah.
and, and the engine will cool down a little bit. So one of the things that I've read about is when writing a will, some of the things have been neglected. Like for instance, your social media accounts, your cryptocurrencies, your your online accounts that you have that are not included on your will, and it
Mhm,
becomes a challenge when you have passed and now we need access to those things.
mhm.
How do you mitigate that?
You nominate somebody. You nominate an executor for that.
Yeah. Okay. Does a will override a nominee form in terms of the nominated beneficiary on the will? This is from Esther.
Esther, I hear your question. I think that I need more clarity on that one.
Mm.
On what nominee? Where are you nominating the beneficiaries from? However, if I understand you correctly, let me just break this down. If we are talking in terms of, say, you've got a life policy where you nominated beneficiaries and you are not putting it as part of your estate, then the beneficiaries you nominated will get whatever you left for them. Now, if you are at work and you're talking about, yes, I assumed you're talking about your company, your money's in your company. So that's a very interesting one, Esther. If it's in the company, you are only nominating beneficiaries as a guideline to say these are the people that are financially dependent on me. Now, the fund will decide as to, or the board of directors of that fund will decide whether only the people you nominated can benefit, or the people who have been financially dependent on you, who you didn't mention on your nominee form. So that fund will decide, or the board of directors will decide whether they get or they do not get.
Hmm.
Hope I answered you.
Yeah, no, no, I need somebody to translate it to English.
It's a simple thing.
Yeah.
So now, if you are working and you've got group
Yeah.
benefits at work,
Okay. Yeah.
yes. So with the group benefits, you don't have the rights, I will say. Yes, they give you a nomination form where you nominate who's going to benefit on your group benefits. Remember, I said earlier, if your stepchildren can prove that they were financially dependent on you, they can benefit out of your group benefits, out of your pension funds. Even if you put it in your will, so the will not, that one doesn't form part of your will. So the board is the one who will decide. But yes, you need to have a will to state that this is what I want happening. If there are people who are financially dependent on you and you do not want them to benefit out of the estate of your benefits at work, you can clearly state on the will that you are taking care of them now because you can afford to do that. But they shouldn't benefit when you are no longer there. You choose not to continue supporting them when you are no longer there. Then that will be that's I can't say override, but that's they will take that into consideration, that you clearly specified that you are currently taking care of them. However, when you are no longer there, you do not want them to benefit.
This game. Who came up with this game, though? Eh? No, man, it's treacherous. Eh? Really treacherous.
It is.
Cause I'm just thinking about sorry for harping on one spot here,
Mhm.
but I'm just thinking about the tension that it causes while you're still alive. We're not talking about missing you because you're dead. When you're still alive and they see, or they've read what you have jotted down on your will, and what it what when it changes the dynamics of your family or relationship, knowing that I have a wife or a husband, a second husband or a second wife, from a second marriage,
Mhm.
who says he loves my kids that are brought into the new marriage, the second marriage, but they will not be catered for when the estate has been executed, the will has been executed.
So now it will depend on the type of marriage you enter into, the marital regime. Now, we spoke about it in our previous shows. that it's
Yeah.
important to choose wisely when you're choosing your marital regime. Because if
Mm.
you are married in community of property, now the new spouse will have 50%, and they'll be talking about, they will inherit 50% of the whole estate. And now when you are talking 50%, you talking your own 50%. Even if I said I love your kids, you can cater, it's a decision that you will make to say, on my 50%, I want it to be distributed amongst my biological kids or whoever I nominate. Then you can see what you do with your 50%, because I left something for you. Now, if you enter into a marital regime where it's the one that you sign in an ANC contract, where it's out of community of property, maybe without accrual, it means whatever you've got, continue with whatever you've got, and I'll continue with whatever I've got, and then I will choose whoever I leave this my estate to. And then if you choose to marry out of community of property with accrual, then it means the 50% of my estate that we are building now will still be distributed. You'll still get your 50%, and then the 50% will be distributed according to my wishes.
Mm. Well, if you just joined us, we're talking about wills and testaments, planning it now while you're still alive so that you can protect those that are left behind. And Fikile, yeah, no,
Yeah,
this is quite not a nice show for me.
I know. It's a conversation I don't really like having, but I
Yeah,
enjoy having with individuals, because I think
yeah.
our situations are different. You can
Mm,
take the whole
mm.
information, but you cannot use all of it. You'll
Yeah,
select
no,
what
that's true.
suits you best. Hence, I prefer consultations with individuals, because we
Yeah.
cater it individually. Whatever works for you, your family dynamics, and then you
Mm,
can put it that way. If you know that your family is gonna fight over your dead body, then you should make sure that your wife knows that there is a will, and when you pass on, it's the first document that she takes out. I had a
mm,
similar experience where one of my closest family members passed on. Everybody had something that the late person said to them, but there was no
mm,
proof. So you're protecting your loved ones. If you're planning it ahead, you're
mm,
protecting your loved ones so that they can mourn you when you are gone. Because if there's no will in place, everybody feels like they are entitled to everything that you own. The family members, like your aunts, your uncles, believe that they've got some type of entitlement on your estate, while they were not even contributing a cent on when you were still alive.
sure. So, do you have different types of wills, or it's just a standard will that you have?
Uh, I will say it's a standard will. It depends on how complicated it gets.
Okay, all right. The reason why I'm asking this, I saw somewhere there's types of wills like simple will,
Hmm.
living will, joint will, and holographic wills.
Okay,
And
you
I wondered what
asking
are
about
those?
that. All right.
Yeah.
So yes, if you are married, you can decide whether you want to have an individual will or a joint
Okay.
will with your partner, with your spouse. If you which one did you mention again?
It's a holographic will, a living
Never heard
will,
of a
a joint
holographic
will.
will. There's,
Yeah.
I know about the simple
Mm,
one is when it's the one that we discussed earlier, to say
yeah.
if you don't have an estate, or you don't have a big
Mm,
estate, but you
mm,
need to have something in place, you can just draft it to say, okay, when I pass on, this is how I want it to be executed. And you mentioned a living will, which is very important, to decide while you are still
mm,
alive and everything is still fine. When you get to you've got a condition where you are in hospital, and you cannot make decisions for yourself on
yeah.
what you are, like whether you want to be kept on a machine or not. Say you are brain dead, and
Mm,
you don't want to continue living because it will cost your family members an arm and a leg to keep you alive. You can decide that you want the machines to be switched off. They don't have to ask anyone. The will speak on your behalf because you cannot make that decision for yourself. That doesn't mean that when you are in ICU, they can switch off the machines. But when the doctors declare that, you know what, there's no hope, we kept this person on machines for over a week or over a month, and there's still no hope. This person is basically dead. We just need to switch off the machines. Then you can state that's what we call a living will.
So clearly, there's a difference between a will and a funeral cover.
Definitely.
Can you have both?
Yes. So a funeral cover, it's that covers for your funeral, right? And then a will is what speaks on. That's why we say it's a last will and testament. So it's what I want happening with me or with my belongings when I'm no longer there. So that's you speaking when you are already gone.
Okay. So let's wrap up. We had everything about wills and testaments and the do's and don'ts. For the benefit of those that have just connected, we just wanna highlight few things about wills, and you can help me with this, Fikile.
Okay.
We need to know the importance of having a will. Why is having a will very crucial in our lives? And we also discussed different types of wills that one can have. And we also discussed the components of a will. So in these components, we have an executor, the one who's responsible to manage your estate, paying debts, and distributing assets according to the will. And we have beneficiaries. Those will explain how you have to name the beneficiaries, including family members, friends, organizations, and charities. And you have assets, which include your bank account, your property, your investments, your personal belongings. Those will have to be highlighted. And you have a guardianship. Before I get into there, I see there's a message on the group, on the chat.
A will stencil from bookshops, is that considered valid? Yes,
That's
for
a
will
there.
to be valid, it can be a template that you downloaded online and you completed it and you signed it. As long as it has been signed currently in South Africa, we need the wet signature, that is hand signature, and has two witnesses. It's considered a valid will. However, if your estate is complicated and you didn't have like advice from you don't have an estate planning, you didn't see a lawyer, you didn't see your financial planner or advisor, you just drafted it. As much as it is valid, but now the little things that you didn't plan for will just make your will invalid, even though the will itself is valid.
Okay.
So if you've got an estate, if you know that you've got an estate, I'd advise you to get an estate planning, so that whenever you draft a will, you can be able to cater for whatever is in your estate, and you will know exactly what is happening in your estate.
All right. So here's another thing there. What would you advise the viewers here or the listeners on the triggers that these are the triggers that says to you need to go and update your will?
Very interesting.
I would assume it will be when somebody else dies.
Yes. When a big event in your life happens, whether you're getting married or somebody passes on in the family, I will say you can actually update your will. when you unfortunately we are obligated to change your will as and when you want to change it, but if you didn't see eye to eye with your wife, that's not a valid reason why you should change your will and remove them,
But can you do
however,
that?
people do that. I've got
Okay,
a
okay.
client who changes their will for like every month. There's this person they taking out and putting back in. You play that because it's the client's will. However,
Yeah.
that's not really grounds for you to change your will.
Mm,
But
mm,
if there's big events like the beneficiary passes on, or you have made a conscious decision to say, this child of mine is not going to benefit out of my estate from now on because I tried 1, 2, 3 and it doesn't work, and I don't want to leave them anything that belongs to me. You are welcome to do that. However, even if that uncle this week and you want to remove them in your will, it's fine, you can do that, but it's a lot of paperwork for us.
and the birth of a child, eh? I
Yeah.
assume.
And the
Don't
birth of a
forget,
child,
eh?
yes.
And they're 18 and they're not included in their will. Yeah, no, it's gonna
If you
be
want to
something
remove
else.
them,
Yeah.
you can do that.
Yeah. Well, in summary, thank you so much, Fikile, for all that information that you just given us. And thanks to all those that have connected on Telegram. We really appreciate your support, on a weekly basis that you put aside time to come and listen to us. And when we impart information, we inviting professionals, those that can lead us in the topics that we talking. And to wrap up, what would be your last advice on wills and testaments?
My advice is that everybody needs to have a will in place. I mean, it's a simple document that will change a lot in your loved one's life. We often don't get time to mourn our loved ones because we need to constantly be fighting with other family members with things that could have been catered for. So it is very important for you to have a will in place, whether it's a basic, simple will. It's better than not having anything. Whether you've got like assets, because some people believe that I need to have a lot of assets for me to have a will. No, draft a simple will to say this is what I want happening, whether it's today or tomorrow, and then keep on updating it at least yearly. Check if everything is still in place. If you need to update anything in your will, do that. It is a free will, a national will week. So I think all the lawyers, all the advisors out there, anybody who drafts a will is drafting it for free. So you shouldn't worry.
Okay.
Utilize this time wisely because you're not going to pay anything for it to be drafted for you.
Oh, that's nice. We love freebies.
Oh, yes, I am actually giving away those freebies from today until Friday. So if you
Yeah.
want your will drafted, you can just contact me. I will do it for you.
All right.
Catering for individuals.
Oh, that's awesome. Hilda, you have your hand raised there.
Yes, I just want the contacts of Figile, please.
All right.
I must utilize this week as well.
Yeah. Figile, do you want to share your number or your email address?
You can share my numbers,
Email.
Neo. I
Okay.
can give you my contact number. I
Okay.
prefer WhatsApp calls. 071 186 8267. You can send me a text or you can send me a WhatsApp.
All right. I have to tap it down there for Telegram. It's 0.
Okay, let me type it on the chat as well.
Yeah. You can say that again. 071.
071
Yeah.
186
186
82
82
67.
67.
Yes.
Okay. So I've sent a message.
One thing, Neo,
Yeah. Yes,
one
sir.
thing that I wanted to find out, if I want, can you hear me now?
Yeah, I can hear you.
Yes.
Yeah.
Okay. So if I want my will to be drafted, must I bring my spouse with?
No. If you want your individual will, you don't have to bring your spouse with. But if you want to have a joint
Okay.
will, then that's when you need to have your spouse with.
So basically, individual
Okay.
will only caters what you have from your side.
So that's
you
your
bring in.
50%. You're talking
Okay.
about your 50%, yes.
Okay. All right. Makes sense. All right. No.
Now, the one that I want now is how to be buried.
That's the one. You need to be specific.
Yes.
I just want to be cremated. This thing of the whole week people coming in and out, I don't like it. It
I
depresses
agree
me.
with you.
Yeah. I'm there too. I'm there too. Yeah. Yeah. It
I mean,
also.
I need to give my family members the time to moan,
Yeah.
to have
To
that
mourn.
conversation instead of entertaining all the people that haven't spoken to me in a year. They want tea, they want coffee.
You
My
understand?
kids cannot moan me because they are being sent left, right, and center.
Yes.
No.
Yeah. Mourning, is very important, but you're not able to do that when you have people coming in.
Exactly. You have to put
you-
on a smile.
Yeah. For African culture, it's kind of difficult to introduce cremation. But I think it's something that we need to revisit. Maybe we'll have a show about it and see how it goes.
Yes. Yes.
Now talking about our African culture, I kept on telling my dad that I want to be cremated, and he said, because when he saw that I was adamant about being cremated, he's like, "You make sure that you die when you are in Gauteng. I'll do whatever you want. But if you die when you are home, I'm just gonna bury you."
You wouldn't know anyway.
I won't know anyway.
All right. No, we're laughing about this, but it's a very serious matter. We need
It
to really
is.
visit with families what your wishes are, and because if they're not aware of it, then we fight.
Yes.
Unfortunately, you are not there to defend yourself to say, "Yay, this is what I want to do." But those that are left behind will be fighting. I will be saying my wife wanted to be cremated, and then the in-laws will say, "Yeah, why do you want to burn
what are you
our
hiding?
child?"
Why are you
Exactly.
why are you doing it? What are you hiding? What did you do to our child?
Yeah. But thank you so much. As we
the nice sound that we love.
Is the producer saying we've run out of time. But thank you so much for joining NMP Talk Show. These discussions are burning. We really need to talk about them. And thank you for your comments. Thank you for putting time aside so that you can join us. Listen in on Telegram, on Riverside, on YouTube. And we will have this show not pre-recorded, a recorded show of this episode on YouTube and all the podcasting platforms that we do have. So be on the lookout on that recording for this week. So my name is Naomi Rapedi, the host of NMP Talk Show, and I'm with my co-host Fikile Nkosi, and we're signing out.